perfect. No, no, no. They said more perfect. In other words, it's going to be better than the Articles of Confederation, which was the previous union. They never intended this to be perfect. That's why there's the possibility of amendments. Establish justice, ensure domestic tranquility, provide for the common defense and promote the general welfare, and secure the blessings of liberty for ourselves and our posterity, do and ordain, establish. Common defense and general welfare come up again in the famous Section 8 of Article 1, which is the powers of the Congress. And again, have been twisted out of shape and out of recognizable form. But nobody really looking at previous documents will understand why, because the phrase was used in the Articles of Confederation. They were also for the common defense and the general welfare of the United States. Nobody had a problem with that. I think that's because nobody had any money. Okay. Now, I have not been able to memorize all of this, so you'll have to excuse me. We're going to go through the Constitution bit by bit. It starts with Article 1, Section 1, which is the legislative vesting clause. In other words, all legislative powers shall be vested in a congregation of the United States which would consist of a House and a Senate. This whole section is part of what was called the Grand Compromise. You had the large states and the small states. Well, if everything was done by population, the small states would have been, frankly, left out. Okay? Why? Because they didn't have a whole big population. New York had a population, Massachusetts had a population, Virginia was the most populous state, Philadelphia, Maryland, and Delaware. I mean, they're not a big deal today. They were not much of a big deal then. But they were a sovereign state. They wanted to protect their sovereignty, and they wanted to make sure that they would have proper representation. The House, therefore, it was agreed, would be on the basis of population, and one for every 30,000. It was originally 40,000. They changed it to 30,000 at the last minute. But that was a maximum. In other words, the House could set a specific number, which is why we don't have, 30,000 representatives there anymore. And then the Senate would be the same number from each state. This is how the small states were brought along into the compromise. They would be treated just as the big states. Another side note that I forgot to mention earlier, Philadelphia was where we had the Constitutional Convention. The population of Philadelphia at the time, which was one of the most populous, actually the most populous city in the country, was 43,000 people. Ramapo is 117,000. To get some concept of the differences, which we sometimes have trouble grasping. The problem, then it goes in choosing them, etc. But because of the legislative powers are granted to the Congress, many of the court cases have dealt with delegation of powers. It used to be a big deal because the Congress could not delegate to somebody who would then act in a legislative fashion. OSHA, EPA, all of these creations of government are acting as delegations for the Congress and passing laws and passing rules and regulations. That the concept has become a nullity by the courts. They don't bother with it anymore. They did for a while, but now they don't. In a 1928 case, it was stated that legislative action is not a forbidden delegation of legislative power, which is very cute. It means nothing. All right? It just throws the whole concept of legislation away. All right? Section 2. If I went through these as thoroughly as they deserved, they'd be dragging us out of here. Okay? I'm only going to get through Article 1 today. Okay. All right. It was direct popular election of the House. Okay. This is part of the Grand Compromise. Everything, when you hear about the elections, is part of that Grand Compromise involving the small states and the large states, which was crucial. Otherwise, there would not have been a constitution. Section 3, Clause 3 of Section 2 is property, wealth, and indebtedness were rejected by the framers as lack of qualification for Congress. This has come up, particularly in the Powell versus McCormick court case, where it says, nope, they use it in the negative, but this is what it says: no person shall be a representative who shall not have attained the age of 25 years, been 7 years a citizen, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. All right? Now, some of this has been changed by amendment, but basically this is telling us that these are the qualifications. We also know that they can be thrown out. They can be expelled, but they can't be excluded. And this is where the Adam Clayton Powell case fell apart, and the Supreme Court said, no, you can't do that. Why? Because exclusion is not permitted. Being expelled is, because the House can say who is to be a member over and above these. And they can't say, yes, you're a member, but we're excluding you. That wasn't considered permissible. Okay? Section 2, Clause 3, further. All right. This is the part that has been changed by Section 2 of the 14th Amendment, but it goes, representative and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, yada, 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 yada. All right. Peoples bound in service for a term of years, including Indians not taxed, and 3/5 of all other persons. Now everybody understands that 3/5 of other persons meant slaves. The South insisted that their slaves be counted as people. The North said, they don't pay taxes, they don't vote, why are we counting them? Again, one of the compromises. And you know, I'm sure you've heard rabble-rousers saying, they don't think we're people, they only thought it was 3/5, so they don't really think we're people. No. First of all, Dumbo, if they had counted the slaves as each person, it would have given the South infinitely more power in the Congress. You would never have had a war for Southern independence, because they would never have let it get that far. They would have controlled Congress. Okay? So the 3/5, although it increased Southern power a little bit, kept it within manageable means. They were saying 3/5. They knew they were people. Somebody I saw speaking about the Constitution said, you know, it's very simple. The anti-slave laws in Georgia were some of the harshest in the country. Or the slave laws. They could not meet more than 2 or 3 of them. They couldn't. There are lots of things they would not permit. Otherwise, you would be punished or whatever. The one difference was, if they were to meet with a minister, they could do that as a large group. Now, you don't permit that if you think they're just animals. They knew the slaves were people. Can't be emphasized enough. Yes, it was wrong. It was a blot on America. At the same time, within the Constitution, it says slavery shall be abolished 20 years from now, in 1808. First country that did that. Right? And then, of course, we fought this major war, in which 600,000 people died to essentially free the slaves. People will say, no, it was Southern independence. Well, in the bottom line, the Southern independence was because they wanted to keep the slaves. It was a war about slavery. The point I'm making is not slavery was good, it was horrid. But the people of the South knew that their slaves were people. They didn't give them all the rights they should have had, but they knew they were people. And counting them as 3/5 made the process manageable, and was, again, another compromise to permit the whole Constitution to go forward. This also was the concept of taxes. And that was a whole other problem. What kind of taxes should be permitted, and how would they be done? And the enumeration is what was included here. All right. Section 2, Clause 3 was there should be a census. All right. And this says the actual enumeration shall be made within 3 years. Actual enumeration means you count people. There were no statistical methodologies in those days. If they want to change it to statistical methodologies, which can be played with, as we all know, you know, there's that famous saying, lies, damn lies, and statistics. and amend the Constitution. As of right now, it says the actual enumeration. That means counting people. And the Supreme Court has agreed with that, amazingly enough. All right?
Another joke.
If there's a vacancy, that person can be appointed, or a special election can be held by the executive authority of the state. Again, some of these things I refer to as housekeeping. In other words, they're not substantially important, and they have not been brought before the courts or the Supreme Court particularly. The allocation, Clause 3, is also how the money should be allocated. It is not considered important. And again, 1 to 30,000 was considered the maximum proportion. All right, vacant seat. All right, here we go with section union. So choose the speaker and other officers. Again, that's housekeeping. The Senate and the House have the constitutionally legal right to determine how they're going to operate. President pro tem, Speaker of the House, whatever. This is all done within, because the Constitution said you guys can operate how you want. It has to be legal, it has to be constitutional, but the Constitution is saying set up everything the way you want it. Section 3, the Senate shall be composed of 2 people chosen by the legislature of the state. Amendment 17 changed that to popular election and is considered to be one of the first substantial anti-liberty moves of the progressive movement. It is why the states, it is one of the many reasons, but very substantial reasons, why the states are no longer the sovereign entities that they were. They can no longer say no to Washington. Why? Because the senators who used to work for the state's interest, and if you were from New York, you worked for New York. If you were from Massachusetts, you worked for Massachusetts. Sometimes it would be such an overriding national problem that they could deal with it as a national federal unit. But by and large, you were protecting your state, or getting what you could for your state, which was another way of protecting it. But now, all they have to do is pander to the electorate. And at the time, it was known by many people who were against that this was not a good idea. When I'm finished, I'll be happy to take questions, but I'd like to not stop and go. Okay? This was a disaster. It's one of those...
Gave a Schumer.
What?
Sorry, it gave a Schumer.
And the other thing is, you look at some of the people we were given by the legislatures. Calhoun, Webster, Henry Clay. These were brilliant people. I don't agree with all of them, but they were brilliant people. They were brilliant thinkers. Okay, Article 1, Section 2, Clauses 2, 3, 4, and 5 are more rules and housekeeping about the Senate, and I'm just not going to go there because it doesn't add much. All right? If you want to read it, it's fine. It's how they can... There's more about the Senate because the Vice President is the President of the Senate, and that puts it into a whole new realm, and it had many people very worried when they were looking at the Constitution to ratify it. But it turns out it's, pretty much not a big deal, unless there is a tie. Otherwise, he doesn't have much to do, and most of the time he leaves and has somebody else called President pro tempore, or temporary president. Article 1, Section 2, Clause 6. The Senate shall have the sole power to try all impeachments. While sitting for that purpose, they shall be an oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. There have not been a lot of impeachments. All right, very few. And this was considered, the concept of impeachment at the time of the ratifying was looked at as a protection for the people against rulers, presidents, and Supreme Court justices who got way above their station and were doing things that were not right. We will get to, the meaning of certain words, but impeachment was meant to be a haven of Republican safety from abuses of power by being at all times liable to be impeached. Okay? If it's like this sort of Damocles thing hanging over your head, but not anymore. The Senate actually has discussions whether they're capable of having an impeachment trial because, those people then and us now and yada, yada, yada. They don't think they're able to run an impeachment trial, which means they're getting rid of one of their functions under the Constitution. Article 1, Section 5. All right. Here's the part that I spoke about earlier. Each house shall be the judge of the elections, returns, and qualifications. Yeah. Again, this is the section under which Powell was thrown out. The case was, he could not be excluded. He had to be expelled. This is why. Even though it tells you that you can do that, punish its members for disorderly behavior and with the concurrence of 2/3 expel a member. It's explicitly clear in the Constitution. The House can, with the concurrence of 2/3 of the members, expel a member. They didn't want to do that, so they excluded him, and the court said, no, it doesn't say anything about excluding. You can expel, you can't exclude him. They threw it out.
Censure.
Yeah.
If they could do it,
okay. Again, we have a bunch of other housekeeping chores. Section 6, clauses 1 and 2. Receiving compensation, etc. Again, there are a few cases in some of this about how they can have the compensation, what should be, when, how. But again, this is mostly housekeeping. Section 7, Clause 1, all bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Because the Senate can rewrite the bills, and because the Treasury tends to write and offer revenue bills, much of that has been rendered a nullity. Elbridge Gerry, or Geroi, worried about the Senate's power to amend, and as it turns out he was right, because the Senate can not only amend a bill, they can rewrite the entire bill, which we have seen happening. Okay? So this is something people were worried about at the time. Elbridge Gerry signed the Declaration of Independence. I think he signed the Articles of Confederation. I don't believe he signed the Constitution. Section 7, Clause 2, Article 1. Presidential veto power, which is important, but also how bills must pass both houses of Congress and be subject to veto. Now, there was the old pocket veto, which actually the court said no, and Ronald Reagan said, forget about it, and I'm pocket vetoing anyway. Pocket veto is this. It says the bill, once presented to the president, must be returned within 10 days with his objections, or it will become law. If he didn't veto it, it just became law automatically. And by the way, it says excluding Sundays, so the 10 days didn't include Sundays. They were very specific. However, when Congress went into recess, if they had passed a bill 2 days before and they went into recess, and the president didn't want to sign the bill or didn't want to veto it, he would just nominally put it in his pocket, put it in a drawer, whatever, and it would die. Because there was no 10 days to return it. They couldn't return it because they were going to be gone. They were, they were on vacation or something. The pocket veto has been used. FDR used it a ton. Ronald Reagan used it a lot. It hasn't been used much recently except for some appointments. The reverse, as it were. Okay? Okay, that's the easy, quick stuff, really. Section 8. Section 8 is the biggie. It is the explicit writing of the powers of the Congress. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, that all duties, imposts, and excises shall be uniform throughout the United States. That's clause 1. This is where that general welfare phrase comes in as law, not as a hortatory point in the preamble. And this has been stretched because, oh, we can raise taxes for the general welfare. Well, the Social Security bill, when it was presented to Congress, for the general welfare of, okay? That's not what it meant. A. B, it says very specifically, general welfare of the United States. In other words, this was for the welfare and well-being of the nation, not of individual pockets of voters to keep them happy. And how do we know that this is not meant that way? Because before that it says, provide for the common defense. Well, guess what? In order to provide for the common defense, they had to have a specific right under law to raise and support armies, to provide and maintain a navy. All right? Are you going to tell me that provide for the common defense is also as nebulous as general welfare? No, they had to specifically found an army, have a navy. The same thing with general welfare. The general welfare is included in all of this. We'll get to that one, that's fine. Next, to borrow money on the credit of the United States. This is one of the major reasons, in point of fact, that there was a constitutional convention. The United States, under the Articles, were flat broke, owed everybody money, and none of their letters of certificates of payment were honored anywhere. Not only that, the British would not relinquish some forts in areas that were given to us by treaty, because they said, wait a minute, you guys aren't enforcing your own laws. You're not repaying the loyalists like you're supposed to. You're not returning property like you're supposed to. Hey, we'll stay here. They couldn't get the Spanish out of parts that had been given to them by the British. They said, who are you? You're not paying it. We were looked at as a nobody, as a nation, and justifiably that bothered some people. So to borrow money on the credit meant you had to have credit to borrow money on. And the ability to have that credit, to have a sound currency and a sound economy, was part and parcel of why the Constitution was written. Oh boy, here it comes. To regulate commerce with foreign nations and among the several states and with the Indian tribes. Okay, nobody really has a problem with foreign nations. Okay? The state of Illinois cannot have a private trade deal with a country. Right? That can only be done through the United States having a trade deal with the country. Not a problem. Commerce with the Indian tribes, again, the states could do it, but the Constitution is saying no. That is strictly to be done by the federal government. But oh my, to regulate commerce among the several states. A fellow by the name of Thomas Jefferson saw exactly where that was leading. Congress are authorized to defend the nation. Ships are necessary for defense. Copper is necessary for ships. Mines are necessary for copper. A company is necessary to work the mines. And who can doubt the reasoning who has ever played at the house that Jack built? If you're not familiar with it, look it up. But I'll give you the Jewish version. Okay? This is actually used in Wikipedia. My father bought one kid. Then a cat came and ate the kid. Then a dog came and bit the cat that ate the kid. Then a stick came and hit the dog that bit the cat that ate the kid my father bought. Then fire came and burned the stick that hit the dog that bit the kid, yada, 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 until you get to... Then the angel of death came and slaughtered the shepherd that slaughtered the bull, that drank the water, that put out the fire, that burned the stick, that hit the dog, that bit the cat, that ate the kid my father bought. That's the same concept as the house that Jack built, and Thomas Jefferson recognized early on that's what would happen to the Commerce Clause. And boy, did it ever. Back to general welfare for just a minute, because I didn't want to forget this. James Madison, as president, okay, he was presented with a bill in 1817 for making internal improvements such as roads and canals. He vetoed it. He said, in part, the legislative powers vested in Congress are specified and enumerated in the 8th section of the 1st article of the Constitution, and it does not appear that the power proposed to be exercised by the bill is among the enumerated powers. Regarding the general welfare phrase specifically, he said, to refer the power in question to the clause to provide for the common defense and general welfare would be contrary to the established and consistent rules of interpretation as rendering the special and careful enumeration of powers which follow the clause nugatory and improper. Such a view of the Constitution would have the effect of giving to Congress a general power of legislation instead of the defined and limited one hitherto understood to belong to them. Did anybody read Judge Silverman's decision on Obamacare, where he said, the Commerce Clause seems to be the main thing that's been going on these days, so yes, the Commerce Clause says it's okay. What? Hold on, guys. What? The Commerce Clause has been, and we will go into this more next week. The Commerce Clause, you talk about being stretched out of shape, it's pathetic. Again, regulate means to make regular. Crucial. And now, a lot of the rest of Section 8 is really not controversial. Commerce with the Indians, naturalization, bankruptcy claim. Now that was actually done to protect people from the state laws, which were much more in favor of the debtor, of the person who was owed the money than the poor debtor. And those were brutal, so that was taken care of. The coinage claim, weights and measures. In weights and measures, there was actually zero argument about it. They just said, yes, we put it in. Counterfeiting. Post office. The biggest problem with the post office, other than the fact that it's totally inefficient because it's federal, is the fact that the congressmen have the franking privilege. Now, the frank is just their signature. And with that, they can send out all the mail they want to the tune of hundreds of millions of dollars a year. Inferior courts. Yes. During the early decades of the 19th century, the courts were starting to realize that judges might eventually revise the law. Not just say, this is what the law says, you're not doing what the law says, that's wrong. But, well, the law says it, but it really means this or that or the other thing, and therefore, everything's okay. And they wanted to begin to reorganize, and it was called instrumentalism. In other words, they used their power as a judge to slowly change the power of the law. It is now rampant. The number of courts, federal courts, that actually say the Constitution says no are very few and far between. All right? It's just different from what the framers conceived of. The framers said no, there was no stare decisis. In other words, don't they, well, we permit this because the previous court said in this decision that it's okay, so we're saying it's okay. No, you were supposed to go back to the document, see if it's permitted in the document, and if it's not permitted, it's not okay. That has not been done in an awful long time.